Judgment in the matter of R versus Mackinlay and others.
Lord Hughes will explain the judgment of the court.
This appeal concerned a narrow issue about the correct meaning of the statutes which control the incurring and declaration of election expenses and put a limit on what can be spent. The appeal arises in the context of a challenge to a preliminary ruling in criminal proceedings where the trial has not yet begun. That means that no one yet knows what the real dispute or disputes may turn out to be at the trial, nor does anyone know how far the legal question which this court was asked will in the end turn out to matter. Because this is that kind of preliminary criminal appeal, it is very important indeed that nothing is reported which anyone could suggest might influence the jury when the trial comes round. So the Act of Parliament which allows, exceptionally, preliminary appeals like this to be mounted also lays down reporting restrictions which must be observed. The judgment that this court gives can be reported. So can the names of the defendants and the charges so far as they are summarised in the judgment. There are some other details like the names of counsel and solicitors which can also be published. But what can be published is set out in the Act of Parliament, and what there cannot be is discussion in advance of the trial of the case which is likely to be made either by the prosecution or by the defence. All that must wait for the trial. In the meantime, the legal question which the court was asked to resolve was this. The statutes say that expenses which are actually incurred by a candidate in a parliamentary election count towards his limit only if the person incurring them is either the candidate himself, his nominated election agent, or a person authorised by either of them to do so. But then in a different section of the statute, it provides for what are called notional expenses. And by that, the statute means things or services which are provided to the candidate for election purposes, either free of charge or at a discount. The statute says that if such things or services supplied in that way are made use of by or on behalf of the candidate, and would, if he'd incurred expenses himself, have counted as election expenses, then they go towards his limit. And they have to be declared in the same way as actual expenses which he himself incurs. The court was asked to say whether such notional expenses also have to be authorised by the candidate or his agent before they count. The answer to that is no. The statute doesn't speak of a test of authorisation for notional expenses. It uses a differently worded test of whether the things or services were made use of by or on behalf of the candidate. Those tests are different in language. How far they are different in fact will depend on what events give rise to the question. In the present case, the facts which may give rise to the question surround the potentially difficult area of a national political party which invests resources in a particular constituency, either to support its own candidate or to persuade voters against another party's candidate, for example, an opposing party's leader. There then might be a question of which activities and their costs fall to be accounted for against the national party budget limit and which fall to be accounted for by the local candidate under his limit. Since the court's conclusion is that the test is not authorisation, but the somewhat different one of whether the services were made use of by or on behalf of the candidate, the prosecution's appeal on that restricted point is allowed. It follows that the trial must proceed, if this question arises, on the basis of the law as we have set it out. The appeal does not involve any kind of determination of whether the charges brought against the defendants will or will not be made out. All that has to wait for the trial.
The court will now adjourn.